We're here with Eddie Butler and Richard Edmonds in Carey Street, to the rear of the Royal Courts of Justice. We've just come out of the last day's hearing of the EHRC versus Nick Griffin, Simon Darby and Tanya Lumby. Eddie, would you like to explain to the viewers why we've been brought back to court?
Well, on the 12th of March, we had a court order made against us to comply with various orders that were made as a result of the first Equalities Commission case. As far as the Equalities Commission were concerned, we didn't comply with those orders, and they wanted to do us for contempt of court, and that was in June, and it's taken this long to actually be properly heard.
Richard, your thoughts?
The question that needs to be asked here is, why is it that the party and its leading officials are in court in this matter? We know that Nick Griffin and Simon Darby and official Mrs. Tanya Lumby have spent the whole of 2010 in court in direct confrontation with the Equality and Human Rights Commission. The question that needs answering here is, how does it come that the party finds itself in this potentially dangerous and very costly situation? We know that it was a whole year ago, in August 2009, that the Commission notified us that our membership rules restricting membership to Britons as traditionally defined, that is of European ethnicity, that these rules were, in the opinion of the Commission, illegal, and the Commission demanded that we change our party constitution. We all remember that demand, and we all remember the debate that followed, and we all remember that at the end of it all we decided that to defy the Commission, the Equality and Human Rights Commission, which has got the whole power of the British state behind it, to defy would have amounted to this party of ours committing political suicide, which we were not of a mind to do so. The point here is, this whole matter, the debate and the decision to comply, and the EGM, the Emergency General Meeting that was necessary to formalise the decision to comply, this could all have taken place this time last year. The Constitution could have been changed, and the Commission notified that we were complying. All could have been done before Christmas 2009, obviating any need for all these court appearances. And that would have been the end of the matter, full stop. No court appearances, the party could have got on with its business. Instead, the party has spent a whole year in court in direct confrontation with the Commission. The dangers and the costs do not need spelling out, but the question needs answering: how did all this come about?
Thank you, Richard. Eddie, would you like to go into a little bit of detail about the legal arguments we've been hearing?
Well, as the Equalities Commission's barrister said, that we'd only complied tardily, partially and reluctantly with the original order. In other words, we had to publish it on our website, tell our members about the new requirements and so forth, and we did that somewhat late. The more substantial point, though, is that there was two particular clauses which were deemed to be, in our statement of principles, which were deemed to be indirectly discriminatory, and which new members had to sign up to as a condition of membership. And there was also a requirement that new members had to agree to have a home visit to their house. These were all deemed to be indirectly discriminatory, and we were told to take them out. What's the two clauses were 3.2.1 and 3.2.3 for those who are interested. Now, what's happened is that they've been left in there, but they've been taken out as being requirements for a new member to sign up to. But they've been reinserted as requirements for anyone who votes on any internal party matter, including elections to the party leadership, and anyone who attends any sort of party meeting, branch meeting, or EGM or annual conference has to sign up to these principles. So or have a home visit. So in other words, once you've become a member, then you would be potentially indirectly discriminated against, because you wouldn't be able to enjoy the full fruits of being a member. That's the case that the Equalities Commission is saying. Our barrister is saying that the order specifically only said rights of a new member, And so that's what the argument is, whether a new member doesn't have to sign up to those things, but to be a continuing member, if you like, you do have to sign up to those things to enjoy the benefits of membership. That's what the argument's about. It's become a bit of a moot point, but the Equalities Commission are saying it's a subterfuge on our part, and that's what it's about now.
What did you make, Eddie, of the performance of the QCs in this case?
Well, the Equalities Commission's barrister, I've seen him in action a number of times. His name's Alan, and I have to say he is a very capable performer. He's the master of his brief. He knows our constitution inside out. He's been involved in this since last autumn, so he should be. He's clearly well developed his legal arguments. He knows the process of the whole thing, how it's progressed from one case, one hearing to the next, and he is a very good performer in the chamber as well. He sort of dominates the chamber whenever he's on his feet. Our barrister, called David Reed, he's new to the case, but I would say he's actually performed quite well. I'll be fair, he's performed quite well. He's familiar with our constitution, he's familiar with the legal arguments that he's putting forward, and this is in marked contrast to the last Equalities Commission case, the one in March, where our barrister hadn't been briefed. In the best will in the world, we could have had the best barrister there, but he had not been briefed about what was said in the constitution, what our legal arguments were, and so he clearly floundered. This time I must admit that Mr. Reed did do quite well, in fact, with the tools at his disposal.
Where do we go from here?
Well, if we get away with it, in other words, if the two judges accept the case put forward by Mr. Reed, then clearly the Equalities Commission will come back at us for having having reinserted these clauses in, because they will say, and they will clearly win, they will say that we are indirectly discriminating against existing members by making them sign up to these clauses as existing members to turn up to meetings or to turn up or to vote in internal elections. So clearly we can't get away with that for any length of time, those provisions, if we win this case, which is, in my opinion, doubtful in the first place. It's doubtful in my opinion that we probably will get away with it this time. Time will tell. We'll find out in December, I think.
Would you like to comment on the motivation of the EHRC in bringing this case against us?
Well, clearly it's a bit uncomfortable for anyone in a democracy to have a regulatory body or the government limiting your freedoms of association, who you can associate with, and your freedom of speech, and that is at the heart of this regulation. But they're the regulations. The government brought these regulations in, which do limit our freedom of speech, and which do limit our rights of associating with who we want to associate with. That's the law. That is the regulations. They're a regulatory body, and regulatory bodies enforce the regulations that they're given to regulate. That's just how British society works. It works the same whether it's for people putting out the wrong sort of rubbish in their dustbins. It works the same for parking, parking restrictions. It works the same with speeding down the road. It works the same with planning regulations. That's what regulations are about, and it's far better to, if you want to operate within society, you have to abide by the regulations. If you don't, it's going to cost you heavily. And if this goes against us, and I think the findings of the judgment will, I think, come out in December, from what I could judge from what was said in there. I don't think the judgment will be released until December, I suspect. And if we lose, we're looking at the wrong end of £150,000 with the costs from the previous case, which haven't even been paid by us yet. And you can't afford to operate in an environment where it costs you £150 for going up against a brick wall. That's just what it is.
Thank you very much, Richard, and thank you very much, Eddie.
Yeah, very good.